everyone, and thanks for tuning in. Today I'm going to talk a little bit about an oral argument that CCK participated in last week on January 10th. The name of the case is Phillips versus McDonough, and the broader issue in the case was whether the veteran was entitled to potentially an effective date for a total disability based on individual unemployability back to 2002 instead of the 2020 date that the Board of Veterans Appeals assigned. But there were still broader questions intertwined in this case, including whether the new VA administrative appeal system under the Appeals Modernization Act, or the AMA as we call it, whether that new system basically erased all of the veteran-friendly rules that were announced in this case, Rice versus Shinseki. And in that case, which was under the old legacy system, the court held that the effective date of an award for TDIU should not be tied to the date that a veteran first submitted evidence of an unemployability. Usually you do that on a VA form 8940, but rather should be tied to the date of any underlying disability rating claim. So in other words, if you file an increased rating claim, and then 2 years later, while VA is adjudicating that claim, you raise the issue of TDIU, Rice versus Shinseki says, the date of the award of TDIU is not the day that you raised it, but the date that you filed the increased rating claim. Another kind of sub-issue here is whether VA's forms actually control everything. So in 2015, VA made new rules that everything, claims, notices of disagreement, everything has to be on one of their specified forms. And so the question here is whether when the veteran submitted an 8940, VA form 8940, while his skin rating claim was pending, whether that VA form 8940 started a brand new claim stream. So what happened in this case, how it even got to oral argument and before a panel of 3 judges, is that the Chief Justice actually issued a decision in the veteran's favor and held that the board erred when they assigned the 2020 effective date because it could potentially go back to 2002 when the veteran submitted a skin claim. After the chief judge issued that decision, the VA filed a motion for reconsideration or consideration by a 3-judge panel and seemed to have argued that Rice, those favorable rules about the effective date of TDIU that the court announced in Rice, do not apply under the AMA system. In other words, once Congress created this new appeal system, the rules changed, and Rice is not a rule that survived the AMA. This oral argument was actually quite difficult because VA's position seemed to shift a bit. It shifted a bit in the pleadings, where VA in one pleading said that Rice was not inapplicable under AMA, but then in the next page said it was hard to imagine any AMA case in which Rice would apply. And there were also some shifts of position during the oral argument itself, which 2 of the judges pointed out. According to the VA, sometimes Rice applies in AMA, sometimes it does not, but it should not apply in Mr. Phillips's case. And from my vantage point at counsel table, I was really unclear on why it didn't apply in Mr. Phillips's case, according to VA. So we'll see what the court thought of that. If the court agrees with us, with CCK, that Rice still stands in AMA, then nothing will really change. The favorable rules that the court announced in Rice versus Shinseki will stand, and the effective date of an award of TDIU remains tied to any underlying pending claim, and the submission of a form will not start a brand new claim stream. If VA prevails here, it will change a lot. It will mean that every time somebody submits an 8940, or at least sometimes, according to the VA, although it was hard for me to understand where the line is, but when a veteran files a VA form 8940, that could start a new claim stream, which the VA will adjudicate separately from any underlying rating claim. And the veteran has to pursue new review options every time VA issues a decision on the 8940. So it would really not only create a lot of confusion for veterans and their representatives about what's being adjudicated where and what part of the system, but also really clog up VA's own system, which was, part of the purpose of the AMA was to kind of unclog the system with a bunch of claims. And so it seems that VA's position would actually do the opposite of what the AMA was intended to do. But we will see. Hopefully we'll get a decision soon, and then we will be talking about it then. So please stay tuned.